this episode was directed specifically at married couples. If you are a married couple, your estate plan was written for you before 2013. We are talking to you.
Yeah.
Get that thing out, take it to your attorney, figure out if there's something else you want to do differently. And I would say one final piece. I'm just going to reiterate what you said. If you are a widow or widower and you haven't yet met with your attorney, do it. Just do it. Even if it was, 10 years ago, you need to talk to your attorney and see what your options are.
Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
This is a very interesting day. As it happens, today is the day that our United States Supreme Court is hearing oral argument in the case in which Colorado held that Donald Trump can be kept off of the ballot in Colorado. Madison, have you listened to any of that?
I have not. Was it interesting?
It was interesting. I didn't listen to all of it. And it's a charged issue. So that's all I'm going to say here on this podcast. Except I am also going to say that I sure am glad that the hearing ended before we went live today.
I'm definitely curious to see how fast the Supreme Court can make decisions.
Oh, yeah.
It seems like that's not going to be a June decision, They're going to be a little quicker.
That will be interesting. Okay. Hello, everyone. This is Absolute Trust Talk, our live streaming February 8th, 2024 version. And I'm Kirsten Howe, here with Madison Gunn with Absolute Trust Counsel. And we are very glad to have you here today. Madison, in our firm, we have a small handful, I think, of pieces of advice that we feel we can't say enough. We can't write enough blog posts. We can't stream enough. We can't put enough on social media. We're just constantly repeating this same bit of advice over and over because it's so important. And the one we're going to talk about today is keeping your estate plan up to date. And we really say it like we're like evangelists about it. We're constantly talking about it, but we are constantly finding people who fail to do that. And so this is just one more effort in that realm. And here, what we're focusing on in particular is, I'm just going to call it the dreaded AB trust. Madison, why don't you kind of walk us through sort of the background on these types of trusts?
Yeah. So an AB trust is generally, in a nutshell, when the first spouse dies, the trust has to split into two, according to some formula that the trust says. And now you have an irrevocable trust and a revocable trust. So one that can't be changed and one that the survivor can change. And there's all kinds of work and detail that go into that we're not going to go into because every trust is different and everybody writes their trust differently. But the big reasons why people set their trusts up like that is usually twofold. It's either because they're a blended family and they want to make sure that, surviving spouse doesn't cut out any stepchildren. But the biggest reason we see that is that for estate tax purposes. Back when the estate tax exemption was really low and there was no portability for unused exemption, having your home would put you, owning a home in the Bay Area would put you over the edge. So they would set it up that way so that they could avoid estate taxes. They didn't want to have a widow have to pay a tax bill. So that was the biggest reason why that was set up that way.
Yeah. And that was very, very common that a married couple would have a joint trust and the trust would say, when the first spouse dies, we're going to divide the trust assets into two trusts. One is the trust for the deceased spouse. One is the trust for the surviving spouse. And the surviving spouse still has access to all of it, but the surviving spouse can't change the deceased spouse's half. And that was very, very common in it. The goal was to eliminate estate tax by using up both spouses' estate tax exemption amount. That's the way we had to structure it in order to use both spouses' estate tax exemption amount. So I'm going to just give an example of what I'm talking about because this is all kind of abstract. So let's say in 2012, the estate tax exemption was $5.12 million. You don't really need to memorize that. Let's just say $5 million. And
but
so per
right?
person.
Yeah.
So if we had a married couple in 2012 with a joint estate worth $6 million. If husband dies, their trust would say, now we're going to take his 3 million because it's half of the 6. We're going to take his 3 million. That's less than the exemption amount. So that's great. No tax. We're going to put his half into what's called a bypass trust, a credit shelter trust, an exemption trust. They all mean the same thing. We call it a B trust for today. We put his into the B trust. And then when the wife dies, her half, also $3 million, is also less than the exemption amount. So no tax on her death. And so that's how that worked really nicely to a degree. If the goal is to avoid paying any more taxes than you have to pay. Well, so that's great. The ungreat thing about it is, it costs a lot of money. It takes a lot of time to do that splitting. So the surviving spouse is paying to split the trust into 2 trusts. And surviving spouse has now an irrevocable trust. And what happens with that?
It has to pay its own tax or file its own taxes every year, which is an additional expense. And that's not a tax return that you can do on TurboTax or that even all CPAs. So it's a specialized tax return. And also good luck finding it.
That's a whole other
problem.
Topic.
But yeah, it's annual administrative costs. That's a big one. And then also there's other tax issues. You might have saved state taxes, but there's going to be other taxes possibly for your beneficiaries because of what's in that bypass.
Right. Okay. So that was the standard. We did that in 2012 and earlier. And then in 2013, what happened?
In 2013, they gave us what's called portability, which means you could file an estate tax return even if you didn't need to. So like typically you only have to file an estate tax return if the estate is more than the exemption amount. But now you don't need to, but you can optionally so that you can use your deceased spouse's unused exemption. So do you have an example queued up? So I don't walk all over that. Okay.
Yeah. We can go back to that same example. If that same couple, we look at them in 2013 after we have portability, and now they're going to update their trust so that it says when one spouse dies, we leave everything to the other spouse. We aren't putting anything into a bypass trust. It's just going to stay where it is, and the surviving spouse has control of it. So what that means in my example where we had a $6 million estate, the surviving spouse's estate is now $6 million. And if she dies, that's more than the $5 million exemption. She's in a situation where she would have to pay estate tax, or her estate would have to pay estate tax. However, when her husband died, he didn't use any of his $5 million because he left everything to his wife. That doesn't count for estate tax purposes. What you leave to your spouse doesn't count.
Yeah, the unlimited marital
deduction. So he left everything to his wife. He didn't use any of his $5 million. She can now later, when she dies, years later, she can use his unused $5 million, add it to her, whatever it is, $5 million. So she has $10 million. And so if she dies with $6 million, she's fine. No estate tax. Now, because of this law in 2013, which we, informally call portability, we don't need that bypass trust in order to use both spouses' exemption. It's a gift from the United States Congress and IRS. We don't need all that complexity that, Madison, you just were talking about, splitting it, the extra tax return every year.
Yeah, it's important to note that some trusts allow you to do that, and most trusts require you to do that split. So it's not like you have an option. And so that's where the rub therein lies, so to speak. That's where it causes the problem.
Right. That's exactly what we're talking about, is if, there are still all the time, every month, I would say, we get a new client who comes in. Why don't you talk about how we typically discover these things?
Yeah. So they typically come in because, we'll just say a wife, because, we're pros at killing off the husband on the show. Yeah. So we will get a widow that comes in. They want to update their trust. No big deal. They bring us a copy of it, and it says that it was supposed to have split upon the death of the husband, which might have been 25 years ago. It might have been last month. We don't know. And a lot of times they don't. So it's a combination of updating your trust, but also knowing what it says. I mean, that's a big part of it. I would imagine, this is before my time, but I would imagine back when the estate tax exemption was very low, that wasn't even a conversation that attorneys had with their clients. That's just how it was. So they don't even know that that's what their trust says.
Yeah. And that is very, very often the case, that once we discover this and we sit down and read the trust, and then we explain it to our widow client they're surprised.
Yeah.
I had no idea that's what it said. I didn't know I was supposed to do all of that.
And it's not, neither one of us like having to break bad news, in a meeting like that.
Which, who cares if we're uncomfortable? It doesn't matter. I'm just pointing. Yeah, she's just pointing out.
No one wants to get that
like
either.
That.
Yeah.
We have to do it, and we do it, but it's unpleasant for us as well as for our client who didn't know this. Okay, so we discover this all the time. Client wants to update her estate plan, and we have to say, well, basically you have two choices. Madison, you want to talk about that?
Yeah, so you can split it. You can split the trust and do it the way it was supposed to be done on the spouse's death. And that can be a little bit difficult because you have to go back in time and look at what the assets were as best you can at that time.
Yeah, especially if the first spouse died 10, 15, 20 years ago. Yeah. That can be a little more challenging.
Yeah. And then you have to have that ongoing trust and, trust tax return and all that fun stuff. And that's a big conversation. It's a project, right? And then the alternative option that you have now is that because it's an irrevocable trust, you can petition the court to modify the trust because of changed circumstances, meaning now the estate tax exemption, $13.2 million per person, and you have portability and, XYZ issues. So you can say, they didn't realize that that changed how their trust was, affected, and you can petition the court. But that's a whole other slew of things that you might not want to be involved in. It depends.
Right. Yeah. So basically, the choice is follow the trust as written, and you, our new client, the widow, you can change your half, but you can't change the other half.
Right.
Or in some situations, we can go to court and ask to have the trust modified so that you don't have to split it in two. And the argument that we make to the judge is, when we wrote the trust, we needed this, but now it turns out we don't need to split it in two because things have changed. The law has changed.
And if they grant it, then you can change the whole trust.
Then you can change the whole trust. Right. So, and generally speaking, that petition is going to be less expensive than splitting the trust and retitling all the assets and that ongoing obligation to file tax returns every year. There's a couple of other advantages to doing the petition in an appropriate case.
Yeah. And that's typically, a capital gain tax issue, meaning anything that goes into that bypass trust does not get the second step up in basis on the surviving spouse's death. So the kids would end up with a tax bill, not the widow, but they probably don't want their kids to have a tax bill either.
Yeah.
I mean, it's the whole point of doing the trust and the estate plan.
Right. Exactly. Okay. So I guess we might want to just briefly walk through what that petition entails.
Yeah. So it's a written petition to the court, not a judicial counsel form or a form you fill out. It's a written petition, and you have to explain, what those changed circumstances are. You have to explain what the assets are. Obviously, you can't say that the circumstances have changed. We don't have an estate tax problem if you actually do have an estate tax problem. So you have to prove to the court that you didn't have an estate tax problem when your spouse died and that you don't have one now. So you have to show that. And then you also have to notify all the beneficiaries in the trust. So they get copies of the trust. They get copies of the petition. They have a chance to object to the court if they want to. And the probate court's pretty lenient. They can just show up at the hearing and object verbally. They don't have to have something submitted in writing in advance necessarily for the judge to allow the objection to go through. They'll eventually have to do that, but you're not going to know ahead of the hearing. So that is something that people may not want. They may not want their kids involved in their estate planning. They may not want, if you don't have children and you've just named a bunch of friends or charities, there's obviously going to be an issue, particularly charities. are going to cause a problem for that.
Yeah, those you made sort of by inference or implication a couple of points. One is this isn't always going to work. It really depends on who the beneficiaries are. If it's, mom and two adult children and everybody gets along, the children want what their mother wants and the children want the best tax result for the whole family, and they're not going to cause any trouble. But, your point is well taken. If it's anything other than that,
yeah, you run a risk.
There's a risk that somebody will object and you won't be able to do it. But contrasting this petition process to the let's just keep our estate plan up to date in the first place.
Right. Yeah, that's much easier.
Yeah, that's a real easy comparison. So first and foremost, you should be able to have the estate plan that you want. And with this petition process that's happening after one spouse dies, you basically are having to get the consent of a bunch of other people to have the estate plan that you want. We don't like to see that. We don't like that. And expense.
Yeah, that always emergency or crisis, dealing with things after the fact. What is that phrase? You'd rather beg for forgiveness than ask permission. That's usually more expensive than asking permission. So, it's usually a lot easier to make that.
Planning ahead, it's always better to pay your lawyer to do a plan than to pay them to fix a failure to plan afterwards. Fixing is always more expensive. And, privacy. While you are alive, there's no reason why anybody else should know what your estate plan says. But if you have to go through this petition process, they're all going to know. So people don't like that.
Not to say we don't think you shouldn't talk to your kids about your estate plan, because we don't want to mix that up and misconstrue that. But that doesn't mean they're entitled to know everything either. Talking to them about expectations is different than saying, here's a copy. Do you approve?
Right.
Yeah. And asking their permission.
Yeah. We don't like our clients to be in that position where they have to basically say to their kids, is this okay with you? And they should be able to do whatever they want. Okay. So Madison, is there anything else you want to say about that?
I want to say, for us, we tell our clients if there's a big change in the law, in terms of estate taxes and things like that. But if you're not hearing from your existing estate planning attorney, there's no reason why you can't bring that into another attorney if you don't have a relationship with your prior estate planning attorney, or you didn't have an attorney drafted at all. There's no reason why you can't bring your existing trust into any estate planning attorney and have them take a look at it for you and let you know. We don't own those documents. If I wrote a document, doesn't mean they can't take that to a firm in San Francisco and vice versa. So just so everybody is aware of that. You own your document. It doesn't matter who wrote it, but you should understand what it says.
That's a really good point. I do sometimes get that question. Well, what do I do? Do I have to tell the other attorney that I'm working with you now? No, you don't. Your documents work with whoever you like.
Yeah, it's transactional. It's not, you don't typically have someone on retainer to update your will or trust. So you don't have to fire anybody.
Most people don't. Yeah. Okay. And as Madison said, this is a point that we make constantly. So valuable to everyone involved if you keep your estate plan up to date. And this is a big one. We still see it all the time, even though it's been over 10 years since that law changed. We're still seeing it. And we're going to probably see it for the next 20 years until all of those trusts age out. Unless somehow our message gets spread far and wide and people act.
It goes viral.
Okay. So I'm going to turn to questions from our viewing audience. Okay. Can you still do a petition for modification if the first spouse died 10 years ago? So that's a specific number, but we can answer that question.
Yeah, you can. We would call that, colloquially, we call that a stale, trust administration, but you can absolutely still do it for 20 years later, as we've seen. So we've done it all the years.
That's probably the most common, is that the surviving spouse comes in and the first spouse died several years ago, that we discover that. It's a little more challenging the more time has gone by, but it still can be done. So
I would say, you mentioned that we mentioned over and over again to keep your trust up to date. If your spouse dies, go talk to your attorney.
Yeah, sooner rather than later. Because sometimes there are options that need to be taken advantage of kind of soon.
Yeah.
I don't mean like in 30 days.
No, but not 5 years later.
Yeah.
Like maybe, go see them 3 months later and
when you're
get that taken care of.
As soon as you're feeling up to it, make an appointment and at least talk to them. Make sure you're not missing out on any opportunities.
And your kids can take you to that appointment. That's okay. So you're allowed to bring your moral support and your support system. It's not something where you got to be cornered alone or anything like that. So it's just, we routinely deal with entire families and they want what's best for you too. So we just want to make sure you don't miss out on anything.
Yeah, that is an excellent point. When somebody dies, it's a good idea just to talk to the attorney. And maybe there's just a tiny little bit that needs to be done. Maybe there's nothing that needs to be done. Maybe there are some choices that you need to act upon. So don't let time go by. Okay, one more. How long does the petition for modification take?
Yeah, so it depends.
Of course it depends.
Depends on what county you live in and the probate court. The good news is it's one hearing. So if nobody objects, it's a one hearing process. You file the petition, they set a hearing date out, 4 months roughly. They're not reviewing any type of accounting or anything elaborate. There's not an investigator involved, so it doesn't take as long as other things that could pop up. But let's say 4 months, and then about a week before, they'll tell us if we're missing anything or they want any further information. We get that taken care of, and then we go to the hearing. And most of the time, as long as there's no objection, it's granted.
Yeah. Okay. I think that's it for the question. So, Madison, any final thoughts that you want our listeners to take away?
Yeah, dust that thing off and read it. Or call us and we'll read it for you.
We'll read it. Yeah.
We know exactly what we're looking for.
Yes. So this episode was directed specifically at married couples. If you are a married couple, your estate plan was written for you before 2013. We are talking to you.
Yeah.
Get that thing out. Take it to your attorney. Figure out if there's something else you want to do differently. And I would say one final piece. I'm just going to reiterate what you said. If you are a widow or widower and you haven't yet met with your attorney, do it. Just do it. And even if it was, 10 years ago, you need to talk to your attorney and see what your options are.
Yeah. And at the very least, you probably need to update other things, even if your trust doesn't have that AB. You probably want to update who's making decisions.
Yeah. There's possibly your power of attorney and all those kinds of things need to be freshened up. Okay. Well, thank you, Madison. Thank you to our viewers and listeners. I hope you got something valuable out of this and that you'll pass it on and share it with your friends. Because again, we are evangelizing. We want everybody to know. Okay. And thanks for joining us. We look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcounsel.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.